The earning threshold is the maximum amount of earnings by the employee that is determined by the minister in terms of the Basic Condition of Employment Act, of which it excludes some of the employees and from the rights and the protection that is afforded in terms of the Basic Conditions of Employment Act. So this earning threshold is reviewed by the minister on the advice of the commission, and then it sets the maximum. So employees who are earning above this earning threshold, they are partially excluded from certain sections or protections of the Basic Condition of Employment Act, and the employees that are earning less than the earning thresholds, they are fully covered by the Basic Condition of Employment Act. The employees that are earning above the earning threshold, they are currently excluded, for instance, from Section 9, of which is dealing with the ordinary hours of work. They are also excluded from the protection of overtime, also with meal intervals, and also with rest periods. They are also excluded from this protection. These employees are considered as not vulnerable because they are assumed to have the bargaining power that they can negotiate in terms of this section with the employers, and they have the more bargaining power to negotiate their conditions of employment regarding this excluded section. So how does it affect the workers? As the earning threshold excludes certain rights and protection under the Basic Condition of Employment Act, it means then those sections that are excluded or do not apply to these employees, meaning the employees cannot claim these rights from the department, or they cannot lodge a complaint with the Department of Employment and Labor inspectors to enforce these rights. Of course, they do have some other avenues. They can go to the labor court, they can go to the magistrate court, or they can go to the small claims court if it involves the money, and they will have to check the jurisdiction of the amount that they are claiming in order to approach those avenues or those other institutions that are dealing with the enforcement of this right. So, but with the employees that are earning below this earning threshold, they can approach the Department of Employment and Labor. Then our labor inspectors will be able to enforce by issuing the compliance orders if there is any contravention in terms of the Basic Condition of Employment Act. And the other thing that the earning threshold now provides is that the employees who are earning less than this earning threshold, if they are owed any money in terms of the Basic Condition of Employment Act, they can now also approach the CCMA for CCMA to enforce their employers. So if the employee is owed by the employer, maybe for a salary, or the employer is not paying the national minimum wage, the employee who are earning less than the earning threshold can choose to come to the department, or they can go straight to the CCMA for the failure of the employer to pay the wages or salaries or any monies, and the CCMA will be able to assist them and enforce wages or monies owed. The earning threshold provides certain benefits or certain rights for the employees, or I can say it differentiates between the employees earning above and the employees earning below the earning threshold in the Labor Relations Act. In terms of the employees who are doing the temporary work, those employees that fall under temporary employment services, those employees who are earning above the earning threshold, in terms of the Labor Relations Act, they are now can be deemed to be working permanently for the client. And also the other benefit for the earning threshold is in terms of the Employment Equity Act, that the employees earning less than the earning threshold that is determined by the minister, they can now, after they've referred their any unfair or any case at the CCMA, they can now, after conciliation, have an automatic right to go straight to arbitration. But it's not the case with the employees that are earning above the earning threshold. There are certain conditions that need to apply to them for the CCMA to hear their case. So in terms of the Labor Relations Act, the employees who are on the fixed term contract for longer than 3 months and the employer fails to prove that it is justifiable to fix the contract to 3 months, those employees now who are earning less than the earning threshold, they can be deemed to be working for the employer on the permanent basis. So they can approach the CCMA and CCMA will take their case. And also the employees that are earning above the earning threshold who are working for the temporal employment services in terms of section 198A3B, those employees who are earning less than the earning threshold, they can be now deemed to be the employee of the client of a temporal employment services, and they may be deemed to be employed on an indefinite basis if their work for the client is exceeding the period of 3 months. So also those cases, they are referred to the CCMA, not the Department of Employment and Labor. And in terms of the Employment Equity Act, the dispute regarding the unfair discrimination, such as on the basis of gender or pregnancy, marital status, or family responsibility, or sexual orientation, if those disputes at the CCMA remain unresolved after the conciliation at the CCMA, employees earning less than or below the earning thresholds now have an automatic right for CCMA to arbitrate that dispute, but the employees earning above the earning threshold do not have such an automatic right for the CCMA to arbitrate that dispute.